Your witness.
Thank you, Mr. President. Mr. Vassar, my name is Mitch Little. I'm with the law firm of Sheaf & Stone, and I represent the elected Attorney General of Texas. We've much to discuss. I'm going to try to pick up a few crumbs here. The word that I heard at the end of your testimony was co-conspirators. Do you remember that word coming out of your mouth?
Yes, sir.
One of your concerns on September 30th was that if you didn't go to the FBI immediately, someone would think you were co-conspirators with the elected Attorney General in this state, right?
That was one of the concerns, yes, sir.
And your attorney that you hired before you went to the FBI is a man named Johnny Sutton, correct?
That's right.
And he's here today, correct?
He is.
And he's sitting in this courtroom, yes?
Yes, sir.
Would you indicate him for us?
It's right there.
Yes. And he represented a number of you employees at the Attorney General's office, correct?
Yes, sir.
And by the time that you went to the FBI, Mr. Vassar, just tell these senators, did you know who performed the home repairs and renovations at the Paxton's home?
No, I had no direct knowledge.
You didn't have any indirect knowledge, did you?
It was discussed when all of the events came together and we met as deputies on September 29th. That was mentioned as one of the potential concerns of bribery of the Attorney General.
Who mentioned it?
Based on my recollection, it may have been Mr. Brinkman.
And Mr. Brinkman heard it where?
I'm not sure.
He heard it from someone else, correct?
I'm not sure.
You don't know?
I don't know where he heard it.
But one of the criminal complaints that you and your group of people who went to the FBI alleged was that the Paxton's home was being renovated at the cost of someone who was under federal investigation, correct?
You said one of the criminal complaints. I'm not, we did a verbal complaint.
Yes.
At the office, but I'm not sure.
Let me be clearer. One of the things that you told the FBI in your meeting with them was that you were concerned that someone else was paying for the home renovations to the Paxton's home, correct?
Me individually, I had no knowledge, but yes, in the meeting with the FBI, with all of us present, there was a roundtable discussion about some individuals' good faith belief that the Attorney General was involved in bribery.
A good faith belief based on what?
I'm not sure. It wasn't my direct knowledge.
You were in the meeting.
Yes, I was in the meeting with the FBI. But
what was the basis?
I'm not sure. I think it was redoing the kitchen countertops.
Redoing the kitchen countertops? Is that what you heard?
I'm just giving you the context of what I recall.
Did you see any documents exchanged with the FBI in this meeting?
No, sir.
Not one?
No, we did not provide any documents to the FBI.
And let me be clear, because I think your testimony was a little bit confusing, at least to me. It may have been to the senators as well. But you learned about Brandon Kamak's signed contract with the Attorney General after you reported the Attorney General to the FBI, correct?
I think that's correct, yes.
So when you went to the FBI and you told presumably some FBI agents that Brandon Kamak was out serving grand jury subpoenas without authority, you did not know that that man had a signed contract with the Attorney General of this state's signature affixed to it, correct?
That's my recollection.
Well, surely when you found out, you went straight back to the FBI and told them, right?
No. I mean, at the time, we were represented by Mr. Sutton.
Surely at that time, Mr. Sutton asked you to go back to the FBI and correct that misinformation, correct?
What information, what misinformation? That Mr. Kamak had a contract?
Yes, he had a signed contract affixed with the signature of the elected Attorney General of this state, correct?
Yes, based on what he had provided to us was a signed contract, and General Paxton had confirmed to us that he had signed a contract.
And you had it in hand, correct?
Yes.
And surely your lawyer said, guys, we need to go back to the FBI and tell them that there's a signed contract with the affixed signature of the elected Attorney General of this state, right?
There wouldn't have been any reason to provide them with a signed contract because that wasn't part of the complaint that we had filed with the FBI.
Part of the complaint, let's be clear about the complaint, okay? Part of the complaint to the FBI was that Brandon Kamak was out serving grand jury subpoenas to support someone else's agenda besides the people of the state of Texas. True?
Yes.
And at some point after your meeting with the FBI, you discovered from Brandon Kamak that he had a signed contract with the elected Attorney General, correct?
That's absolutely true, for nothing that he was doing.
And I'll object to the non-responsive portion of the question or answer and move to strike, Your Honor.
Strike the last comment.
Now, let's be clear about something else. After this contract that was signed by the Attorney General of the state of Texas, Ken Paxton, he had the authority to enter into it, correct?
Yes, I believe he did.
And that's because over 4 million voters in this state gave him that authority, correct?
Yes.
And that authority exists to bind this state. And if the voters don't like it, they can vote in someone else, correct?
That's, yes, how the political system works.
That's my understanding as well. At what point in time did you come back to the FBI and say, well, maybe there was some authority for Brandon Kamak to do what he was doing? Did you ever do that?
No, sir. And just because
Object non-responsive to anything after no, sir, Mr. President.
Please keep your answers to the questions.
In your meeting with the FBI, did you tell the FBI that Ken Paxton had illegally disclosed some confidential material to someone?
we filed a complaint based on activity that we had formed a reasonable belief that.
Mr. President, I will object at this time as non-responsive.
Sting.
Madam Court Reporter, would you mind reading my question back? I should have a, I'm sorry, I don't have one. Yes or no?
I disagree with the phrasing of the question.
It's a very simple question. Did you tell the FBI in this meeting, did someone in this meeting tell the FBI that Ken Paxton had illegally disclosed some confidential information to someone? Yes or no?
In the meeting, we alleged, based on a reasonable belief, that that activity could have occurred, but we were not investigators. That was what law enforcement was for.
That's right. And Mr. Vassar, I want to see us on this point. You're a lawyer and you're doing some, I mean, you have very good command of the language. You had a good faith belief in certain information, but you didn't know that Ken Paxton had disclosed anything to anyone when you made this report to the FBI, did you?
No.
You were hoping the FBI would sort it out for you and not think that you were co-conspirators with him, correct?
No. The purpose of the complaint to the FBI was because we had formed a belief in good faith that the Attorney General was involved in criminal activity.
This is something that I keep hearing over and over again. We formed a good, let me make sure I get it right, formed a good faith belief that the Attorney General of this state was engaged in illegal activity. Did I say that right?
That's accurate.
But you didn't know, right?
Well,
You didn't know, right?
that's the point of the good faith belief, is we had no evidence that we could point to, but we had reasonable conclusions that we could draw.
You went to the FBI and reported the Attorney General of this state with no evidence. Do I have that correct?
We reported the facts to the FBI.
That's not my question. You had no evidence that Ken Paxton had done anything illegal. Did you?
Your Honor, it's not necessary to yell at this witness. I suggest it's disrespectful, and I request he quit doing it.
I apologize. Let me do this again at a lower volume. Madam Court Reporter, would you read my question back for me, please, at an appropriate volume? Yes?
Repeat that, so, because they could not hear her on the microphone.
Yes, Mr. President, I will. You're watching the live stream over there? Hold on. Let me ask this question again. Let me get this straight. You went to the FBI and reported him for potential crimes without any evidence. Do I have that correct?
We went to the FBI and reported
Please answer my question, yes or
our
no.
belief that criminal activity had occurred.
That was not my question. That was not
Witness
my
needs to
question.
answer the question, yes or no.
Did I ask it again, Mr. Vassar?
Please.
I want to get this straight. You went to the FBI on September 30th with your compatriots and reported the elected Attorney General of this state for a crime without any evidence. Yes?
That's right. We took no evidence.
Did you gain any after that? Did you gain any after that?
Well, we weren't collecting evidence.
Did you gain any after that?
Evidence of what, sir? Of
Evidence of a crime committed by the elected Attorney General in this state, elected by over 4 million voters. That guy.
I don't recall if we had collected any evidence.
Don't you think that's something that you should be able to recall, sir?
Well, when we presented ourselves to the FBI, we did so as witnesses, not as investigators to collect evidence.
Did so as complainants, hoping that you would not be named as co-conspirators, true? You made a complaint, yes?
Yes, it was.
Without any evidence, yes?
No.
I'm sorry?
Again, these are our good faith beliefs that a crime had occurred.
Respectfully, sir, we are not here in this historic event for your good faith beliefs. So if you could just tell these senators who are taking up their time and all of Texas's time with this impeachment.
Excuse me, these sidebar testifying comments are an inappropriate form of cross. If you just asked a question, I have no objection.
I will throttle it down. I withdraw it.
Pull that back.
Yes.
Ask a question.
Mr. Vassar, we got a lot of people whose time is invested in this impeachment proceeding. Did you gain any evidence after you went to the FBI?
I'm not sure what evidence that I can recall.
You had a good faith belief. We've heard those words a lot in this trial, a good faith belief, but without any evidence, correct?
The evidence that we provided.
Why didn't you talk to Ken Paxton? I'm sorry.
Please let him finish his answer.
Overruled, he was finished.
Mr. Vassar, when you worked for Ken Paxton, was he gentle?
As far as I knew, yes,
Was he
sir.
kind?
Yes, sir.
Ever yell at you, scream at you?
No, sir.
Don't you think you owed him the courtesy of at least a phone call before you reported a man to the FBI without a shred of evidence?
Well, that's not how the reporting structure worked.
Oh, please tell these senators how it works.
Well, all of my interactions were directly with Jeff Mateer and Ryan Bangert. General Paxton would call me with questions like the open records issue or the foreclosure letter, or I'm sorry, not the foreclosure letter, that was through Ryan Bangert, outside counsel. So every other instance was my weekly meetings with Jeff Mateer and Ryan Bangert. And I never called the Attorney General. He always called me.
I appreciate your answer, but that was not really what I asked. So let me try again. Don't you think you owed the Attorney General of the state of Texas at least a phone call before you reported him to the FBI without any evidence? Yes or no? That's not the way it worked? Yes or no?
Would you like me to answer?
Yes, I would.
Based on our conversations with Mr. Mateer and Mr. Bangert, they were having conversations directly with General Paxton. I was not part of those conversations. So any concerns that they had raised with him would have been in their conversations. I had no reason to call him directly.
Object non-responsive.
Sustain.
Let me try this again, Mr. Vassar. Don't you think you personally, Ryan Vassar, don't you think you owed the Attorney General of the state of Texas, elected by over 4 million voters, a phone call before you reported him to the FBI without any evidence, sir?
I was appalled at the time, so
Object non-responsive.
Sustained.
I object to the continued interruption of the answer. If he doesn't like the answers he's getting, he can then object to it being non-responsive. But jumping in the middle of this, man, is totally unfair, and I object.
I will listen more closely, Counselor. I have not heard him interrupt him. I will listen more closely so the witness can finish his answer and you can do a follow-up question.
Thank you. Can we go
That
back to my
objection's
question?
overruled.
Thank you. May I go back to my question, Mr. Vassar? My question was, don't you think you personally owed Attorney General Ken Paxton, elected by over 4 million voters, a phone call before you reported him to the FBI without any evidence? Yes or no? No, I don't? Yes, I do.
well, I would disagree that we didn't have any evidence just based on our beliefs, but I don't think I owed General Paxton anything.
You don't? You worked for him for 5 years.
That's right, and I believed in him.
He gave you a job, correct?
He did. And promotion.
And a promotion, huh? Not enough to warrant a phone call before you report him to the FBI, though. True?
Like I said,
Do you wish you could go back and call him?
I'm sorry,
Do you wish you could go back in time and call Ken Paxton and talk to him before you reported him to the FBI without any evidence?
I wouldn't do anything else differently.
Interesting. Okay. You don't know anything about Ken Paxton's campaign donations from 2018, do you?
No, sir, I don't.
You didn't work on the Mitty Foundation case, did you?
No, sir.
When you went to the FBI, did you have Ken Paxton's phone number, at least? Could you call him on his cell phone? Did you have the number?
I believe I had his phone number in my phone. Yes, sir.
How'd you get it?
I think he gave it to me,
Why?
just based on working with him and questions that he would call me with.
So you could call him if you needed something, so he could call you if you needed something, right?
That could be an option, just based on a cell phone use.
You even had his secret email address, didn't you?
I'm not sure which one is.
Well, there is an email that's already entered into evidence in this case. It's ag.wkp@protonmail.com. Have you seen it?
Yes.
He gave it to you, right?
Yes.
Did you email him on his secret email address? Tell him that you were going to go and report him to the FBI without any evidence?
No, sir.
Why not?
It didn't occur to me.
Didn't occur to you. At some point since then, has it occurred to you that maybe you should have done that?
No, sir.
How secret could this email address have really been, Mr. Vassar, if you had it?
I don't know exactly.
Do you consider yourself a close confidant of the Attorney General?
No, sir.
Do you think you're the only person that had that email address?
I have no reason to believe that I was the only one.
So this gentle, kind man, was he attentive to your concerns when you talked to him in the office? Talked to him on the phone?
Sure.
Gentle, he's kind, he's attentive. And at what point in time did the weight of what you were doing in reporting this gentle, kind, attentive man to the FBI become apparent to you?
On September 29th.
When you walked in there?
Walked in where?
To the FBI.
No, that was September 30th.
Okay. So what happened on September 29th when the great weight of having to report this gentle, kind, attentive boss struck you? What was going on?
September 29th, I was in a meeting, just a division meeting with Lacey Mays, and she received a text message on her phone from an individual that I did not recognize, and the individual asked if a Brandon Kamek was working for our office.
And you knew exactly who that was, didn't you?
Yes, I recognized the name.
And what happened in your mind was you realized this contract didn't work its way all the way through the executive action memorandum process. True?
Among other things, yes. That's a thought that went through my mind.
Yes, and the rest of that thought is, if that process has not been completed, he has no authority to work on behalf of the Office of the Attorney General, correct?
Yes.
And that was alarming to you, true?
In addition to the fact that he was acting in a capacity that he didn't have, even if a contract had existed at the time.
And in that moment, did you call General Paxton and say, Brandon Kamac's working, what's going on?
No, sir.
Do you think it's possible? Is there room in your mind for the possibility that if you had called Ken Paxton and told him that information, Ken Paxton would have said, yeah, Ryan, I signed the contract with my own hand, with my own pen. Is there room in your mind for the possibility that that would have happened?
Well, it is possible, but he was out of the state at that time. So I wouldn't have been connected to him or had a reason to call him.
You had his phone number. So what if he was out of the state? Cell phone works out of the state, surely, right?
Yes, sir.
You didn't think to call him?
Well, as I explained, because he was out of state, Jeff Mateer was running the office.
That's another thing we're going to get to, okay? My understanding is your belief was that while Ken Paxton was in Ohio working on the Google case, the biggest case that the Office of the Attorney General had, Jeff Mateer was the acting Attorney General, right?
That's correct, although my understanding, in addition to
An object is non-responsive to the remainder of this answer.
Sustain.
Mr. Vassar, can it possibly be in a state with as many millions of people as Texas has, that it is the belief of the upper echelon of the Attorney General's office that any time the Attorney General gets on the plane, Jeff Mateer is the real Attorney General?
only to the extent the government code is triggered. That's what deputizes the first assistant to act under the authority of the Attorney General.
And your belief was that on September 29th and 30th, when Ken Paxton was in Ohio doing business on behalf of the people of the great state of Texas, litigation business, very important litigation business, that someone else was the Attorney General, and that's what the government code says. Is that right?
Well, it was my understanding it was a political event. It was a campaign event. I had no knowledge that he was working on the Google case.
He was doing a campaign event in Ohio?
That was my understanding at the time.
Where on earth did you get that?
Just conversations at the time with Mr. Mateer.
So if he was on, let's say he was in Ohio on a campaign event, Jeff Mateer's the Attorney General while he's there?
I was just clarifying my understanding based on your question. Your next question of whether Jeff Mateer is the acting Attorney General, again, that would depend on the statute. The statute provides if the Attorney General is absent or unable to act, the first assistant shall perform the duties.
Tell the senators what absent means.
The statute doesn't define it.
Tell me what you think it means.
Well,
Out of the state?
It would mean the ordinary meaning of the word under a statutory interpretation approach.
Tell these senators, many of whom are very accomplished attorneys, what the word absent means to your understanding, please.
I am not advised of what the dictionary definition would be. That would be an interpretive guide. Absent could mean out of state. Absent or unable to act could mean incapacitated.
Like if Ken Paxton was on life support in a hospital somewhere, for example.
I presume so.
But he wasn't. He was in Ohio, which I guess is debatable one way or the other.
I'm not aware if that statute has ever been interpreted by a court. So I could not be able to say.
But in any event, it provides the perfect cover for someone in your office to remove Ken Paxton's name for the letterhead and begin sending out letters on behalf of the Attorney General of the state of Texas. True?
No, nobody removed his name from letterhead.
You don't think so?
No, sir.
Have you ever seen Attorney General's office letterhead without Ken Paxton's name on it?
All the time.
All the time.
Yes, sir.
How did correspondence in September of 2020 come to be sent to parties outside of the Attorney General's office without Ken Paxton's name on it? Tell us.
Well, the agency has different letterhead. There probably even today, letterhead that's available on the Attorney General's website that does not have his name on it.
So-
Letterhead that he signed.
I see. So when the Attorney General is absent in Ohio, someone at the office goes, grab me the letterhead without Ken Paxton's name on it. He's in Ohio today. Is that right?
I don't recall any decision about using this letterhead or who instructed the use of the letterhead.
No one decided, it just happened, right?
Like I said, I don't recall any decision about it. The agency has different letterhead that exists today.
You're familiar with the Mitty Foundation now, right?
I've heard of it, yes, but
You've been an attorney how long?
I was licensed in 2012, so 11 years.
You said your family goes to a Baptist church, right?
Yes, sir.
Okay, that Baptist church is organized as a nonprofit, right?
Yes, sir.
And at some point in time, I'm sure you've given money to a charity, correct?
Yes, sir.
I gotta ask you something that's just been really bothering me, and I know I'm not the only one. What in the heck is a charity doing making a multi-million-dollar private equity investment with Nate Paul with charitable funds? Any thoughts on that?
I'm not sure. I don't know.
You ever ask anybody?
No, I was not involved in the Mitty case, was never consulted on it or provided any advice for it.
Do you know, maybe you do you know of any charities that make multi-million-dollar private equity real estate deals with charitable funds?
I have no personal knowledge.
Okay. Do you recall giving testimony to the House Board of Managers and being questioned on video by Aaron Epley, Brian Binkin, and Therese Buse?
Yes, sir, I remember.
But they never put you under oath, did they?
Not that I recall.
Did that kind of surprise you?
I didn't think anything of it.
Did you ask why not?
I don't know. I don't think I did.
Well, just because you weren't, well, you are an attorney, obviously. Just because you weren't under oath doesn't mean that you didn't tell them the truth, the whole truth, and nothing but the truth, so help you God, true?
That's right.
Did you review your statement in preparation for this historic trial?
No, I consulted with my attorneys, and that was it.
Did anyone give you a copy of it?
A copy of my statement?
Statement, yes.
No, sir.
So anything that you said in that testimony, I guess we can call it testimony, anything you said in that testimony that's recorded, we can take as the gospel truth, right? Yes?
Just based on my telling the truth, is that what you're asking?
Yes.
Yes, sir.
We can take it as being true, yes?
Yes, sir.
Okay. Have you ever, before today, have you ever in your life been asked to give testimony as a witness without being sworn?
I don't recall. I've been a resource witness to many Senate and committee hearings, but I don't recall if there is an oath administered to a resource witness. So I apologize.
Have you ever given sworn testimony anywhere before today?
No, I don't think so.
It's a tough first outing, isn't it? Mr. Arroyo, if you would, Article 1 of impeachment, please. Can you see Article 1 on your screen, sir?
Yes, sir.
You don't know anything about this, do you?
No, this would be the Mitty Foundation matter.
And just to be clear, Have you looked at Chapter 123 of the Property Code to determine what the Office of the Attorney General's obligations are with regard to charities in this state?
No, sir.
Don't know anything about that, do you?
No, sir.
All right. Mr. Arroyo, Article 2, if you would. Now, Mr. Vassar, you've given some testimony about what we'll call the foreclosure opinion, right? That was issued August 1,
Yes, sir.
issued August 1 of 2020? Yes?
Yes, I believe that's right. It was a Sunday.
That opinion was not a legal opinion under Subchapter C, Chapter 402 of the Government Code, was it?
Yes, it was a legal opinion under Subchapter 402.
It was?
Yes, sir.
That's not what you told the House Board of Managers. What did you tell them?
I don't recall.
We'll get to that later, but that's not what you told them, is it?
I don't recall. I may have misstated.
You may have misstated.
If you're saying that's not what I said, and my testimony today is that there's no other statutory authority except for Chapter 418 of the Disaster Act to issue a legal authority, to issue a legal opinion by the Office of the Attorney General. So it either has to be Chapter 402 or it has to be Chapter 418.
But we know this is not 402 because it says on the face of the foreclosure opinion that it is not under 402, correct?
It does say that it's not, but that doesn't mean it doesn't fall under the authority of that chapter. It just means it wasn't written in accordance with the typical legal opinion process.
I was hoping that we would be able to have a chance to discuss this. Mr. Arroyo, please bring up Section 402.042 of the Texas Government Code. No, we're looking for 042. That's .212. We'll get to that later. Thank you. While Mr. Arroyo is bringing this up, I've got a couple questions for you about that. In order for the foreclosure opinion to have been authorized under Chapter 402 of the Government Code, Mr. Vassar, certain criteria need to be met. Is that correct?
I believe so.
There first needs to be an authorized requester, correct?
That's correct.
Who are the types of persons who are authorized to make that request?
The governor, the lieutenant governor, the speaker, chairman and chairpeople of committees of the House and of the Senate, executive heads of agencies, and county and district attorneys.
Did any of those people request the foreclosure opinion?
Yes, sir.
Okay. What is the next criteria to satisfy for Chapter 402 of the Government Code?
You're going to have to refresh my recollection.
All right, Mr. Arroyo, if you would move to the second page of that PDF that you just had up. There you go. If you could just highlight the text at the top, that big chunk of text there. A little bit lower. Thank you so much, and just blow that up for us. Let's look at item C, okay? You're a lawyer, we can read this together, right? Right?
Yes, sir.
It says a request for an opinion must be in writing and sent by certified or registered mail with return receipt requested, addressed to the Office of the Attorney General in Austin, or electronically to an email address designated by the Attorney General for the purpose of receiving requests for opinions under this section. Did I read that correctly?
Yes, sir.
That didn't happen with the foreclosure opinion, did it?
I'm not advised if it did.
You were in charge of the section. Is there anybody who has more knowledge about this than you, perhaps?
I don't have access to the email box that it would have been received at. So I'm not aware of how it was delivered, if it was delivered by electronic mail.
Can you tell the senators whether the criteria of Section 402.042C were satisfied? Yes or no?
I'm not sure. I don't recall.
And that you were in charge, right?
Yes, sir. Subsection D allows...
Seems kind of, I'm not talking about subsection D. We're not there yet. Seems kind of important to know whether this satisfies the criteria for the Attorney General to provide formal legal advice. Yes?
Yes, sir.
But you told the House Board of Managers this foreclosure opinion was not formal legal advice, correct?
That's correct.
It was not formal legal advice. It was informal guidance. True?
I believe so.
And during COVID, the Office of the Attorney General was dispensing informal legal advice related to COVID almost every day. Was it not?
It was very frequently. I don't know if it was every day, but
Were you writing the opinions?
some of them, yes.
People who are working for you were writing the opinions as well. Yes?
Yes.
And there were all kinds of COVID opinions coming out almost every day, informal legal guidance from the Office of the Attorney General that did not satisfy the criteria of Chapter 402 of the Government Code. True?
I'm not sure about that. A lot of the things that you're referring to about the daily stuff would have come through Chapter 418, which is the Disaster Council legal function. Those would have come from county mayors or city mayors, county judges, and emergency management directors. Those were coming more frequently than the other ones.
Well, let's build two boxes. In this box, we have Chapter 402, formal legal advice, correct? Okay? So in this box, we place formal legal opinions from the Office of the Attorney General that satisfy the criteria of 402.042. Yes?
Sure.
And it's assigned a KP number, correct?
That's right.
And it's published in the formal opinions section of the office's website, correct?
That's right.
And to be clear, for the ladies and gentlemen of this jury, the foreclosure opinion did not satisfy anything in that box, correct?
No, that's why it was flagged as not a formal legal opinion.
It's in the 418 box. Because at that point in time, the governor of this state had decided to empower the Attorney General to give the people of Texas guidance more freely about what's going on during COVID, true?
That's not true.
It's not true?
That's correct. It is not true.
How did the Attorney General get the ability to give people informal legal advice under Chapter 418 of the Government Code?
It wasn't from the governor. The legislature enacted a statute that the governor signed, giving the Attorney General the power to advise three categories of people: county judges, city mayors, and emergency management directors.
I apologize for my imprecision. So at this point in time, these people, the legislature, at least in part, had empowered the Attorney General to give informal legal guidance more freely, true?
To select people, yes, that's true.
Yes. How select were they?
It's the three categories of people: county judges, city mayors, and emergency management directors under the Disaster Act.
There were people on the House Board of Managers who were requesting informal legal guidance relative to COVID, weren't there?
But that wouldn't have triggered Chapter 418. The only other express statutory authority for a legal opinion is 402.
But if it doesn't have a KP number and it doesn't satisfy the criteria of 402.042, it's not formal legal advice, correct?
That's correct. It's not a formal piece of advice. It's an informal piece of advice under Chapter 402.
One of the things that had to do with your termination, I believe, is you're voluntarily sending secret grand jury subpoenas outside of the Office of the Attorney General to someone who is not authorized to receive them. Do you understand that?
That's never been stated to me, but that's my understanding based on the OAG's whistleblower report.
Well, you don't have to wait for the OAG to tell you that. You know you did it, right?
I only sent copies of records to my private lawyer. I did not send them to any member of the public or disclose them to the public outside of the agency.
Was Johnny Sutton authorized to receive secret grand jury subpoenas from Travis County? Yes or no?
Well, on their face, they weren't valid. Brandon Kamek had no contract. He was not a special prosecutor. He had no authority to request them or to obtain them.
Mark Penley thought they were valid enough to quash and to get a judge to sign an order to quash them, didn't he?
Well, because they were issued.
They were issued. And when they were issued, they were secret. True? True?
I guess unless they were invalidly obtained under false pretenses.
Are you aware of some type of exception that allows you to send secret grand jury subpoenas to your lawyer?
Well, I thought sending it to my lawyer for purposes of legal advice would be permissible. I'm not a...
Did you check and ask Mr. Sutton whether he represented any of the subpoena recipients before you sent them to him?
Yes, in our conversation for him to represent us, we discussed whether he was able to do so.
And after you sent those grand jury subpoenas to your lawyer, copying the rest of the so-called whistleblowers, you deleted that email from your inbox. True?
That's right.
I think you will probably recall at some point in your 5 years of employment at the Office of the Attorney General receiving some type of training in document preservation. Yes?
Yes.
And what types of training did you receive? Please tell the ladies and gentlemen of this jury.
I believe it's an annual information security training. There's annual sexual harassment training. So there's a variety of required annual trainings that employees of the office are required to complete.
In a second, I'm going to ask you, well, let me ask you now. You are not allowed to delete official records of the Attorney General's office. True?
Official records, no. That's right.
In a second, I'm going to ask you whether you deleted emails from your computer that should have been preserved as official records. Do you want to consult with your criminal attorney first?
No, sir.
Did you delete official email records of the Office of the Attorney General, sir?
I deleted emails to my personal attorney under the agency's own information security policy that's provided to every employee that personal messages of a de minimis nature are allowed on agency devices, provided that those messages are deleted to prevent archival. Because I made a determination that I emailed Johnny Sutton in my personal capacity with copies of records, not records that had to be maintained on an agency device, but copies of records that existed in the office, I deleted the personal message to Johnny Sutton.
It seems, Mr. Vassar, that one of the things you are accusing Ken Paxton of doing is by allowing people outside of the Office of the Attorney General to see secret things they should not see. Do I have that correct?
No, sir. Mr. Sutton was my personal lawyer.
No, that wasn't my question. Let me try again. Listen to my question. One of the things that you are accusing Ken Paxton of doing is forwarding secret information of the Office of the Attorney General to people who should not have it. Yes?
That is a suspicion.
You don't even have enough to make an accusation. You suspect that it occurred, right?
Yes, sir.
But that's what you did, isn't it?
No, I forwarded it to my personal lawyer for purposes of legal advice.
And you think that protects you somehow?
Well, if any ordinary person gets a subpoena, I imagine their first call is to their lawyer who reviews the subpoena.
In preparing the foreclosure opinion, Ken Paxton didn't direct you. Ryan Bangert did, yes?
Yes, sir.
And Ken Paxton didn't direct Austin Kinghorn. You did,
That's
correct?
right.
If you would, Mr. Arroyo, please bring up Article 2. This allegation is not true, is it?
Is there a specific part that you'd like me to review, or?
Read it all. Ken Paxton is innocent of this allegation, isn't he?
So the first provision of the second sentence, this is Article 2 of the Articles of Impeachment. Paxton caused employees of his office to prepare an opinion.
Hold on a second. I don't want you to read it out loud.
Okay.
We don't need to waste the jury's time doing that.
Sure.
They can read. Many of them are skilled attorneys themselves. This article is not true, is it?
Well, it is true that he caused employees of his office to prepare an opinion in an attempt to avoid the impending foreclosure of properties.
But you don't know whether those properties belong to Nate Paul or business entities controlled by Nate Paul, do you? You don't know that.
Nothing other than what's been reported in the media.
You don't know that what's been reported in the media. Have you ever heard the phrase self-licking ice cream cone before?
No, sir.
Let me explain to you what a self-licking ice cream cone is, Mr. Vassar. A self-licking ice cream cone is when a bunch of employees at the Attorney General's office begin to suspect their boss. They read it in the media. They believe what the media says. They report it to the FBI. And then the media reports that you went to the FBI. That's a self-licking ice cream cone. Are you familiar with the expression now?
Based on your description, yes, sir.
You don't know whether this article is true or false, do you?
No, sir, I didn't write this.
Mr. Arroyo, Article 3, if you will. Article 3, thank you. You weren't directed to act in contravention or contrary to the law, were you?
No, sir. General Paxton.
Object not responsive to anything after no, sir, Mr. President.
Sustained.
Do you think that your decision with regard to any open records request that was made by anyone was improper?
No, sir.
It wasn't, was it?
No. Everything that we did in a way that we could find a way to make it lawful, because we wouldn't have participated otherwise.
You did it by the book, correct?
Yes, sir.
You wouldn't do it any other way, would you?
That's right.
Mr. Arroyo, Article 4, if you will. Can you see Article 4, Mr. Vassar?
Yes, sir.
Ken Paxton didn't improperly access anything in his office that you're aware of, did he?
No, not that I'm aware of.
And if he wanted to ask for a file, he could do that anytime he pleased, couldn't he?
Sure.
Because that's what 4.2 million voters elected him to do. True?
Yes,
To
that's
access whatever file the heck he wants. Yes?
true.
Article 5, please. We know that Ken Paxton's innocent of this article, right? Right?
I'm not even, I don't recall the distinction about an attorney pro tem. I used to know it, but
You don't even know what an attorney pro tem is, do you?
I know there's two categories. One is court appointed and one is recusal based, but I don't recall the nomenclature.
And Brandon Kamak wasn't either one of them, was he?
He said he was on the
Stop
subpoenas.
there. Brandon Kamak wasn't either one of them, was he?
No, he had no authority.
Wasn't an attorney pro tem, was he?
Honor, he keeps interrupting the witness. He should be entitled to finish his answer.
You're right, Mr. Hardin. I apologize, Mr. President. May I try again?
You may try again.
Mr. Kamak was not an attorney pro tem ever, to your knowledge. True?
Like I said, I don't recall the distinction between the two categories of prosecutors, but he was not hired to be a prosecutor.
He wasn't hired to be any type of prosecutor, true?
But yes, sir.
He was hired as outside counsel because that's how you drafted the contract personally, yes?
Yes, sir.
So when it says Warren Kenneth Paxton misused his official powers by violating the laws governing the appointment of prosecuting attorneys pro tem, Brandon Kamak wasn't a prosecuting attorney pro tem, was he?
Not based on my understanding of what that.
I didn't think so either. Article 6, if you would, Mr. Arroyo. You're familiar with this allegation dealing with whistleblowing, correct?
Yes, sir.
Don't you kind of think Ken Paxton had a right to be upset with you reporting him to the FBI without any evidence?
I suppose he's entitled to whatever feelings he may have felt at the time.
Article 10, if you would, Mr. Arroyo. This says the Paxtons, and it says Ken Paxton, but you understand he's married to Angela Paxton, right?
Yes, sir.
So when somebody's spouse gets accused of bribery, and the form of the bribery is improvements to a home that are owned by both of them, really you're accusing both of them of being corrupt, right?
I don't know.
Don't you think?
I don't know the elements of bribery. I'm not a criminal lawyer, so I'm not sure what the implication could be.
As you sit here today, you know darn well that the Paxtons paid for the renovations and repairs to their home, don't you?
No, I don't know that, actually.
You don't know who paid for them?
No.
Maybe it'll come out in this trial. Mr. Vassar, would you expect to be placed on investigative leave for sending a set of secret grand jury subpoenas to your outside counsel and then deleting that email?
No, sir. I mean,
You wouldn't expect anybody to investigate that?
for sending an email to my personal lawyer relating to my report to law enforcement
Yeah.
and to be retaliated against by being placed on investigative leave. Is that?
No, my question was a little bit different, so let me be clear about what the question is. Wouldn't you expect the Office of the Attorney General to investigate your use of your office email to send secret grand jury subpoenas to that man, Johnny Sutton, and then delete the email? Wouldn't you expect to be investigated for that? Yes or no?
No, not necessarily.
Okay. Wouldn't you expect to be fired for that?
No.
Wouldn't you expect to be fired for reporting your boss to the FBI without any evidence?
No, I would expect an opportunity to answer questions based on answers that I was provided when I asked, what documents are you alleging that I disclosed? And when no response was given, I couldn't give any further information about who the messages may have gone to or for what purpose.
Mr. President, I'm conscious of the indulgence of the hour, and I want to make sure that I'm not running up against any type of deadline or keeping?
We were prepared to go to 7 if needed.
Would you like me to continue?
You may continue.
I will be happy to. You are the chief of the General Counsel Division at the Office of the Attorney General, correct?
At one point, yes, sir.
Yeah, so for the ladies and gentlemen of the jury who are here and may not be lawyers, and for the people of Texas who may be watching, you were really a lawyer to lawyers, correct?
That you could describe it like that. Yes,
That's
sir.
how I would describe it. General counsel is really a lawyer's lawyer, yes?
Yes, sir.
And so what happens in the Office of the Attorney General when you are in the General Counsel's office, actual lawyers come to you and ask you for legal advice, yes?
Yes, sir.
And that happened regularly, true?
Yes.
You were first chief of the General Counsel Division, and then you were Deputy Attorney General for legal counsel, true?
That's right.
And your first involvement with anything related to this impeachment was being approached in the fall of 2019 with a question about an open records request made to the Texas State Securities Board, true?
That's true.
And Ryan Bangert approached you with a question. Remember, you're the lawyer's lawyer. He approached you with a question about whether the State Securities Board's involvement in a joint task force could harm the law enforcement or investigative privilege, true?
That's my recollection, yes, sir.
And you answered his question, yes?
Yes, sir.
And then you were not involved in anything else related to this impeachment matter until March 2020, true?
That's not true. I think it was May of 2020, which was the DPS request.
You're wrong about that, but
Okay.
I just want to make sure I understand what your understanding of the timeline is, okay? So when was the period of time when you believe you first got a request or an open records request related to this impeachment matter?
Well, to back up just a little bit, if I may, I was not promoted to deputy for legal counsel until April 1st of 2020, so I wouldn't have been overseeing the open records division until after April. So I don't know when the DPS request was submitted to our office. That could have been the date that we received it in March, but I wouldn't have been tasked with anything related to it until after I was promoted on April 1st, and then the conversations that I had in May of 2020.
Tell the ladies and gentlemen of the jury who Joe Larson is.
I believe he's an attorney representing Nate Paul.
And what type of work does he do, to the best of your understanding?
I'm not sure. He was a requester in 2 of the open records requests.
Yes.
I don't know if that's his practice.
In fact, Joe Larson works at, he's pretty well known in the state of Texas for being a Public Information Act lawyer, yes?
I'm not sure.
Had you ever encountered him before?
No, sir.
Okay. So I'm going to tell you, my understanding is on March 3 of 2020, Joe Larson sent what I call the big request to DPS. Okay, so the one that happened in 2019 was a request for public information was made to the Texas State Securities Board. Yes?
Yes.
Ken Paxton asked you about the law enforcement privilege. You answered his question. Oh, I'm sorry. Ryan Bangert asked you about the law enforcement privilege. You answered his question. And that went away. Poof. Yes?
Yeah, I never heard anything else. Yes, that's right.
Then March 3 of 2020, Joe Larson made a Public Information Act request to DPS, what I call the big request. He's asking for a whole lot of information related to the search warrant execution on Nate Paul. Yes?
Yeah, I don't know about the dates. Again, I don't know when he submitted it to DPS, but yes, if that's how you want to categorize the big request, then yes, that is accurate.
Well, this is probably beneath many of the people on the jury who very well understand this, but for people who are watching at home, when someone makes a Public Information Act request of an agency in the state, the agency comes to the Office of Attorney General for representation, says, help us decide. Yes?
It's not representation, but it's a request for a ruling.
Yeah, they want a ruling.
Right.
And so in this situation, DPS wanted a ruling. Yes?
Correct. If they want to withhold anything under the Public Information Act, they must request a ruling.
But Joe Larson didn't wait for your ruling, did he?
I don't think I follow.
On April 10th of 2020, Joe Larson sent a demand to DPS saying, I asked for this stuff, give it to me now. Are you familiar with that request or demand?
No, sir.
And on April 16th, he filed a lawsuit to get it. Are you aware of that, sir?
I recall the lawsuit.
I'm going to show you what's been marked as Exhibit 5. And maybe light one copy. Your Honor, may I approach the witness? Thank you.
Thanks.
We move for admission of AG Exhibit 5.
Mr. Hardin?
No objection, Your Honor.
Mr.
AG
Arroyo.
Exhibit
Oh, I'm sorry.
0050 should be admitted to evidence.
Thank you, Mr. Arroyo. Exhibit 5, if you would. This is good. What is this, Mr. Vassar?
This appears to be a petition for mandamus filed by Joseph Larson, as a plaintiff against the Department of Public Safety, April 16th of 2020.
Who did he sue?
He sued the department, it appears.
What did he sue to get?
I'm not sure.
Take a moment and look through it. Maybe you can figure it out.
Sure. So according to count 1, Joseph
You don't need to read it out loud.
I'm not.
Okay.
I'm summarizing.
I'm sorry. Go ahead.
He's suing DPS because of his claimed refusal to produce the information that he requested.
Mr. Arroyo, can you find count 1 for the ladies and gentlemen of the jury so that they're not listening to this blind?
Do you want me to continue?
Not quite. There you go. Thank you. Can you just pull up count 1? Mr. Larson is suing DPS based on his big request for all the documents that DPS has related to the Nate Paul search warrant. True?
I don't know. It looks like, yes. Page 1 references the March 4th, 2020 DPS request for all communications. So we could call that one the big one, if that's the big request.
I call it the big request.
Okay.
Okay, so in the big request, Mr. Larson is suing to get all the raid information. Yes?
Yes, I mean,
Probable cause affidavit. Yes?
it says all communications in this document, but I would assume it would have said all records.
He wants the full Monty.
Right.
Everything DPS has related to the Nate Paul search warrant. Yes?
I'd presume
And
so.
he's suing to get it. Yes?
Yes, it appears so.
And the OAG was aware of this litigation. True?
Yes, we became aware of it. I don't recall when, but
It would be pretty stupid for Nate Paul to sue to get something that he already had, wouldn't it?
well, this predated any conversation. This lawsuit could have even predated a request for ruling to our office. So
Let me press pause there for a second. To be clear, this big request is the request to which OAG responded and said, we take no position on it. True?
yes, the big requests.
Yeah, the big request. So this thing, by the time OAG even decides anything, Joe Larson's already sued DPS to get it. True?
Correct. If I'm following, so this was filed, it appears to be April 16th. The OAG's non-decision in the big request was June 2nd. So this lawsuit, and I apologize if I'm not following you, but
You are following.
Okay.
Mr. Vassar, you are following me. What happened is Joe Larson says, I'm not going to wait to see what the OAG decides on this. I'm suing. Right?
sure, I don't know what he was thinking at the time, but
And the OAG's no decision on the big request did not lead to the production of any documents to Nate Paul, did it?
Not under the Public Information Act, no, sir.
No. But Joe Larson didn't stop there, did he?
If you're talking about the public information request to the Office of the Attorney General for the FBI brief, then you are correct. He did not stop there.
All right, let's press pause there. This third request from Joe Larson was for an unredacted copy of the FBI's brief. Let's go back a step. This is very confusing and arcane, so I want to go slowly, all right? When Joe Larson made the original big request of DPS for the search warrant, etc., DPS had to give notice to the FBI, yes?
Yes, sir.
Because they were holding the FBI's own documents, yes?
That's right.
Said, hey, we're holding some stuff that probably by right belongs to you. Do you want to object? And the FBI has a period of time to object, yes?
That's right.
And what the FBI did in response to that was they sent a legal brief, yes?
Yes, sir.
And that legal brief is a bunch of legal arguments from a lawyer at the FBI, yes?
That's right. The brief identifies the content of the information that the agency wants to withhold.
And the brief that the FBI generated and gave to Mr. Larson was almost completely redacted, like something you might get from the CIA, right?
I don't recall exactly, but based on what I recall, it was redacted.
It was just basically a bunch of pieces of paper with big black blocks on them, right?
I don't recall, but it was redacted. I do remember that.
And Joe Larson says, this is no good. He makes a demand for the unredacted FBI brief. He made a third request, so request number 3 under the Public Information Act, for an unredacted version of that brief. And he made it directly to the OAG's office, yes?
Yes, sir.
He didn't make it to DPS. He didn't make it to FBI. He made it to your office, yes?
Yes, sir.
And what happened is the OAG sent notice to the FBI, the same notice DPS had sent earlier, and said, hey, this guy wants a copy of the unredacted brief. You guys need to show up and object if you don't want him to get it. True?
Yes, that would have been the third-party notice.
And the FBI blew it, right?
I don't recall. I was not involved in those conversations. I don't recall what happened.
The FBI didn't respond in time. True? True?
I believe that could be true. I don't recall. I'm happy to refresh my recollection if you have.
Joe Larson got the unredacted FBI brief, yes?
Yes, I believe so.
And he got it because your office decided the FBI blew the deadline, yes?
That's functionally correct.
Functional? What do you mean? What does that mean?
Well, after we had advised General Paxton about the issue.
What did you need to advise him about? Ken Paxton, hold on a second. Ken Paxton.
Excuse me. He asked him, what do you mean? He's in the middle of answering, and he cuts him off because he doesn't want the answer. Excuse me.
Slow down.
You're very right. My apologies.
Did you want me to?
Did you need Ken Paxton to tell you that the FBI blew the deadline?
I'm sorry, did I need Ken Paxton to tell me that the FBI missed the deadline?
Yes.
No, sir. No. I brought it to General Paxton.
Not responsive to everything after no, sir.
Sustained.
So, after the FBI blew the deadline, Joe Larson got the unredacted FBI brief fair and square. Yes? Yes?
I assume so. I did not provide it to him, but I assume a copy was provided in response to the decision to let the brief go out.
Okay. Just make it like, tell the ladies and gentlemen of the jury like you would a 7th grader. Did Joe Larson get the unredacted FBI brief because the FBI blew the deadline?
It was mainly because General Paxton told us to release the FBI brief.
And he told you to do that because the FBI blew the deadline, right?
I don't know if that's why he told us that.
But they did blow the deadline, yes?
I don't recall. I was not involved in contacting them directly. I don't know what any responses we would have received or when.
Sorry. You're in charge of this, yes?
That's right.
And you can't remember, right?
No, I didn't have direct contact with the FBI about a brief or a notice. Those are all handled by the opinions division.
Are you satisfied in your own mind that the proper notice was provided to the FBI and the deadline was not satisfied?
Based on my knowledge, yes. I didn't see it, but
Nate Paul's lawyer got that fair and square, didn't he?
maybe under the Public Information Act,
The law, you mean?
correct, just under an interpretation of whether sufficient notice was provided or whether a third party submitted briefs that it wanted to submit.
It's just a brief. It's just a bunch of legal arguments, isn't it?
It is.
You told Rusty Hardin when he asked you on direct that this item contained all types of information that would subject law enforcement to potential retaliation, that somebody might come and shoot them at their home or something like that. That's not true.
Well, that's not exactly what I said.
This unredacted FBI brief is just a bunch of legal arguments from some Fed lawyer, isn't it? Isn't it?
The act requires the brief to identify information to which exceptions might apply.
That's all he asked for, right? The brief.
Correct.
So the insinuation that Ken Paxton somehow got the file and sneaky, delivered it to Nate Paul, you don't have any evidence to substantiate any of that, do you?
I have no direct knowledge of what he did with the file when it was in his possession.
You want to make an accusation while you're here on the stand? You want to accuse the elected Attorney General of this state of delivering something to Nate Paul that he shouldn't have? Do you want to do that now?
I don't know what he did.
So when Ken Paxton asked for the file, you gave him the file, right?
Yes, sir.
And he had every right to ask for that, yes?
Yes,
If he just felt like looking at it, he could ask for it, yes?
that's right.
And irregardless of his feelings about Nate Paul and whether he was unjustly being railroaded or the feds are mistreating him, he had every right to look at it, didn't he?
Yes, sir.
And you don't know that Ken Paxton did anything illicit with that file, do you?
No, sir, I don't.
You're not here to testify about any of that, are you?
No.
In fact, when Ken Paxton had this meeting with you about the file, he told you that he had spoken to Nate Paul. He didn't hide that, did he?
No, sir.
He told you he would believe that Nate Paul was being railroaded just like he has been, yes?
Yes, sir.
He told you he didn't trust DPS or the feds, didn't he?
Yes, sir.
And he didn't hide that, did he?
Not in that meeting.
Do you, by the way? Do you trust the feds? Trust the FBI?
Yes, I have no reason not to. I trust law enforcement and our peace officers.
You can't think of one reason in the last 3 or 4 years not to trust the FBI?
I'm speaking mainly personally.
Ken Paxton told you he didn't want to use his office to help the feds in any way, didn't he?
Yes, sir.
He didn't hide that from you, did he?
No, sir.
And when you were discussing the ruling, what I'll call the no decision ruling on the big request, you reached an impasse where each side made its case, and he's the boss, right? Yes?
Yes, sir.
And he didn't overwhelm you. He didn't tell you to do anything against your conscience, did he?
No, sir.
He told you to be a lawyer and make a decision, right?
No, sir.
You made a no decision, yeah?
Well, to clarify, it wasn't my decision to make. It was his decision for the ruling to be a non-decision. There was a couple of decisions in there that maybe confused me.
Have you ever seen the probable cause affidavit in connection with Nate Paul's search warrant? Have you seen it personally?
Yes, sir.
Earlier, you said that you delivered a file to, you gave a file to Drew Wicker, and just show the ladies and gentlemen of the jury with your fingers how thick that manila envelope was. Like that?
I'd say less than 1/4 of an inch, just not very thick.
Probable cause search warrant affidavit is 224 pages, isn't it?
I don't know.
You don't know? You said you saw it.
Well, I saw the body of the affidavit. I don't know if there was anything else attached to it. When DPS submitted its request to us, it was a request based on representative samples of information. So we would have received a representative sample of whatever DPS provided. And I don't recall seeing a document of that size.
Counselor, we'll go maybe 10 more minutes. You can stop anywhere you'd like in between.
You're very kind. Thank you. I want to talk about the foreclosure guidance for a few minutes before we retire for the evening. The legal question from Ryan Bangert was, are foreclosure sales gatherings, quote unquote, since the governor and the local county judges and mayors had prevented gatherings of 10 or more people, right?
Yes, that's what I remember his question to be.
That's really the simple legal question. And you, as a lawyer at the OAG's office, you do your research and then you take a position, yes?
That's right.
Okay. And we agree that what you were doing was not a formal attorney general opinion, true?
It was not formal. That's right.
These are what you call informal letters or announcements, yes?
Yes. Informal opinions. I mean,
Let's save us a little bit of time. I have a transcript of what you told the House Board of Managers. And what you told them was this AG foreclosure guidance was an informal letter or announcement, yes? True?
if that's what you're saying,
Is that what you said?
I don't recall. Again, based on my recollection of 402 and 418, those are the only two statutes that give the Office of the Attorney General express statutory authority to issue legal opinions.
And after Austin Kinghorn did the research and he explained to you his position on it, you talked to Ryan Vassar, true?
Yes.
And Ryan Vassar called you and said, well, that's not the right answer, true?
We prepared a draft and then provided that to Ryan Vassar, and then, yes, he called me and said that's not the right answer.
And Ryan Vassar told you General Paxton wants to stop these foreclosure sales, right?
Yes, he said we reached the wrong answer.
Yes. And so what you know secondhand is Ken Paxton disagreed with the result that you and Austin came up with, didn't he?
Yes, that's what,
And he has the right to do that, doesn't he?
yes,
And he was elected to make those decisions, wasn't he?
yes.
Did Ryan Vassar tell you, you know what, Ryan Vassar? There's two Ryans. I'll sign this so you don't have to ruin your career, Ryan. Did he tell you that?
No, sir, I don't recall.
Did he intimate that?
No.
Did he imply it?
No, it was basically a timing.
What do you mean it was basically a timing? Tell me what you mean.
We prepared the first draft. By the time Ryan had finalized the second draft, it was 11 o'clock at night or midnight, and he was talking with General Paxton, is my understanding. So I had gone to bed and wasn't available to sign it.
Were you happy to sign it?
I would have signed it.
You didn't avoid signing it, right?
No,
You didn't say, Ryan, I don't feel comfortable. Would you sign this instead of me?
no, sir. I didn't say that.
So Ryan Vassar didn't jump on the grenade, so to speak, and say, you know what, this is really dangerous, Ryan Vassar. I'm going to sign it. Did he?
Not that I remember.
Did Ryan Vassar tell you, Ryan, I totally disagree with what we're doing here, but I'm going to do it over my own strenuous objections?
I don't remember him saying that.
You worked on this opinion on Saturday night, right?
It was all day Saturday. Yes, sir.
But that wasn't even the only COVID opinion that went out that day, that Saturday, was it?
I'm not sure. I would have to go back and look.
Well, I'll put it in front of you here in a little bit. You do not have the first clue whether this informal foreclosure guidance stopped a single property foreclosure, do you?
I have no direct knowledge.
And you heard it secondhand from some Austin Business Journal article, right?
That's right.
Did you believe it? Did you believe it?
I had no reason to disbelieve it just based on the timing.
Did you do any research yourself?
No, sir.
Any investigation at all?
No, sir.
Just one problem. It's 100% false. Never happened. It's not true. It's pure fiction. Did you know that?
And no, I wouldn't have had any reason to know that.
Your Honor, I believe this is a good time to stop for tomorrow if Your Honor is willing to conclude for the day.
Yes, court will adjourn for the day, 9 a.m. tomorrow morning.